Good afternoon, everyone. My name is Jason Boakes. I am a patent attorney, and I am a partner at a firm called Secerna. Um, we um, we got the date wrong on the first slide. Apologies, it's not the 10th today. Don't panic. What I'm going to speak about today is intellectual property. I'm going to briefly talk about why it might be important, what it is, how to protect it, how we might create an intellectual property strategy. And I'm going to give you some concluding thoughts that probably are a take home message. Happy to take some questions as we go along if anyone has any. There is quite a lot to cover. There's a big slide deck. I'm not planning to talk at length about all of it. We just won't have time. But after today, if any of you have any particular questions, very happy for you to either contact me or you can contact me through Liam. My details are going to be on the last slide at the end of the show. So that's a picture of me rather than on a webcam. I work for a firm called Secerna LLP. We are headquartered in New York and we have an office in Newcastle as well. Uh, Onto the main matter at hand. Um, why intellectual property matters. And these are some of the reasons why people might be interested in intellectual property. And really, it is about avoiding risk in business. It can help you if you protect your intellectual property, it can help you avoid things that you don't want to happen to you. Um, and it can also give you some benefits, which will be things that you can benefit from if you don't have uh, protection in place. So you can avoid risks and you can also derive some benefits, which, if you don't take any positive actions, you won't be able to gain a benefit from. Um, so, intellectual property, what is it? There are two main types of intellectual property rights. Intellectual property is property. It is an intangible form of property, so you can do things with it. It has value. That's why it is worded as property. It's intellectual property because it's not tangible. You can't pick it up, move it around, and put it in your car and transport it. Um, there are two types of intellectual property rights: registered intellectual property and unregistered intellectual property. We're going to talk a lot today about registered intellectual property rights. They are patents, registered designs, and registered trademarks. In each of those instances, you have to proactively do something to register those rights. There are also unregistered intellectual property rights. These are legal rights that spring into existence automatically because of the underlying legal structure in place. Unregistered design rights, unregistered trademarks, copyright, and trade secrets. We will talk a lot about patents. It's really relevant for the rail industry. Uh, Patents protect technical inventions. They are a 20-year right to monopolize a technical field. The world doesn't like monopolies, but the world uh, grants a limited monopoly right of 20 years to patents. Generally, around most countries, developed countries around the world, you get a 20-year right to monopolize something. After 20 years, your patent dies, something goes off patent, and humankind is thereafter enabled to use that advancement. That's the trade-off. The patent system is territorial by nature. It is country by country or region by region. If you want to try and get a monopoly in a particular country or region, you have to get a patent in that country or region. And as part of this trade-off for getting the monopoly right, you have to make a disclosure. You have to put in the public domain your cruel new idea. You can't keep it secret. Quickly talk about another registered intellectual property right. That's called a registered design. Unlike patents, which protect principles, concepts, invented concepts, registered designs are mechanisms to protect the way something looks. Typically a product, whether it's the shape of it or a particular decoration or some sort of way it looks to an informed user. And if you register a design, you can prevent competitors from making use of the way your whatever you registered looks. They last a slightly different period of time. They can last up to 25 years. And they have some criteria. You have to be trying to register something that has not been done before. It's what's called novel. And it has to have some sort of what's called individual character. Another registered intellectual property right is a registered trademark. So unlike patents and unlike registered designs, you can register a trademark. Most companies have a name that they use, which acts as a trademark. Most companies have a logo or sort of brand logo or strapline that they use. It is possible to register that, all those sorts of marks, according to some criteria. Registered trademarks can be used as an indicator of origin, and you can register words, logos, slogans, sounds, even colors, even. They will be registered for an indefinite period of time. So patents are limited to 20 years. Registered designs, if you like, can last up to 25 years. Trademarks, you can keep them going. You have to keep paying a fee, but you can keep them going for hundreds of years if you like. And the ethos there is that they can stop consumers being confused by the origin of some goods or services associated with those marks. There's an unregistered right called copyright, which may or may not be relevant to you. They spring into existence automatically, these so-called copyrights. They protect original creative works, written stuff, films, musical work, software. Typically, may last 70 years after the death of the person that created the work that is protected, and they prevent copying. Some other rights that are registered protect things per se, regardless of whether someone's copied it. So if someone innocently does something, copyright won't help. Whereas if someone innocently creates something and starts selling something, if you have a registered right, you can still stop them. Trade secrets are another form of intellectual property right. They spring into existence automatically. It's all about confidential information that is held by your business. There's no formal registration process. And a trade secret can be kept as a valuable intellectual property right as long as it remains secret. The problem with keeping something as a trade secret is that if you have churn of staff, and someone within your business has been party to that secret, if they go work for a competitor, one can sometimes find that the competitors find out, but they shouldn't, but they do. Okay, how to protect IP, cheap processes, registered rights. You need to go through a process. I'm going to talk about those. The unregistered rights I've talked about, you don't need to do anything for those. Trying to protect an invention, that would be something you do by trying to secure a registered patent. There is a process. It's common in most countries around the world. It begins with you talking to someone like me, a patent attorney, about your idea. We try and understand the idea that you've come up with, and we prepare a legal document, which is called a patent specification. I'm going to talk about what that means. It's a load of text and drawings, and we give that to an independent third party. In the UK, it's called the UK Intellectual Property Office. In other countries, it is called something else, like the US Patent and Trademark Office, etc. So you lodge or give your information to the third party governmental organization, and then uh, there is a phase which kind of involves two key steps that can last many years. One's called search, one's called examination. Search is where a person that works for the government looks to see whether what you are trying to patent has been done exactly before. They are effectively trying to see whether you're trying to protect something that is new, and they create something called a search report. They tell you about things that have been done before, like your invention, and then something called examination happens. That's where you get into a dialogue with a third party person working for a government. They're called a patent examiner. The patent examiner applies lots of criteria, which are set out in the law in a particular country as to what you can and can't patent. And they write to you, if you're using a patent attorney like us, they write to us on your behalf, and they make some objections, or they say, no, that's fantastic. And eventually, if you're lucky, you can be granted a patent. So a patent is the end result. You have to go through a process to get a patent, and it is only when you have a patent that is granted, it is at that point you have the right to monopolize what you've attempted to patent. Um, and the patent lasts, as I say, it can last up to 20 years. You have to pay a fee. Most countries, that fee is payable each year. We call that a renewal fee. And you pay that for however long until the end of your 20-year period. After that, your patent dies. You don't need to pay any more fees. Patent documents, which are focused on an inventive concept, uh, have some common themes. A patent will have a front page that's full of bibliographic detail, a description, some drawings, and some claims. The front page, you'll tell you who's applying for it, when it was applied for, which country it's a patent application for, and they'll usually include a drawing and what's called an abstract, which gives you a sort of a summary of what is being protected. Description and drawings are in it's sort of required. They have to set the scene. They have to talk about technical background. They talk about how your invention is super cool relative to what's been done before. So they talk about at least one problem that the world has faced before your invention. And they talk, the description and drawings teach the person that's reading it about how the invention solves those problems. And there is also a requirement to provide something called a specific example or a specific embodiment, which teaches humankind, how to put your invention into practice. It can't be theoretically uh, put at that stage. You have to provide a description that is good enough for a skilled person to go away and make one of your inventions. Uh, there's a section in a patent called the claims. That section is the most important section of any patent document. The claims are often considered to be horribly legalistic. They are words, but the words some people find quite tortuous to read. People like myself spend a lot of time trying to carefully choose words. In the claims, they effectively define the scope of protection provided by a patent. And when you work with a patent attorney like myself, uh, the patent attorney will spend a lot of time with you trying to get the claims just right, because they shouldn't include things that are sort of not that important, um, but they need to include things that are important. That was the registered intellectual property right called a patent. Quick whistle stop tour of how you register a design. It's a similar type of thing where you have to go through a process because, again, this is a registered right. That means you're going to do something with a governmental organization. Again, in the UK, it's called the UK Intellectual Property Office. Different countries call that bodies different things. You are required to provide some graphical representations of the thing you want to register a design for. Usually it's in line drawing format, different views, top view, side view, left view, right view, different bottom and top views. So that again is given to the governmental organization, and some governmental organizations, like the US or Japan, they will look to see whether what you're trying to protect or register is the same as what people have already tried to register. Some patent offices or some sort of registries don't even bother doing that. Some registered design applications are made and they kind of automatically just go through to a next stage whereby uh, people that might object to the registration of a design are given an opportunity to object. And if no one objects, the design is registered. So that's quite a quick way of saying registering a design is relatively straightforward, usually. Registering a patent or trying to secure a patent is not straightforward. Patents can usually take many years to try and get. Registered designs, it can be often dealt with within 6 months, something like that. Once you've got a design registered, it also needs to be kept in force. You've got to pay a fee. Again, it's called a renewal fee, but unlike patents, where typically you pay every year, for registered designs, you tend to pay one fee every 5 years, up to 25 years. Trademarks, again, another type of registered intellectual property right. Again, there is a process you've got to go through because you are registering something with a governmental organization. You've got to prepare some original application documentation that identifies the mark that you want to register, whether it's a logo or a name, etc. You've got to give some details of the goods and or services that you're going to use that mark under. That's called classification of goods and services. So, track maintenance, software, etc. You give that to the local governmental organization. Again, in the UK, it's called the UK Intellectual Property Office. Depending on which country you're trying to register your right in, some patent offices, some UK Intellectual Property Office, for example, they tend to just allow the registration to go through, as long as it meets some follow requirements. Some countries have a more rigorous system in place where similar marks that are already registered may cause you a problem seeking to register a trademark. But often it is a straightforward process. Um, again, you can keep the trademark going for many years, depending upon how long you're interested. Developing an IP strategy is something that most businesses are interested in. For some businesses, an IP strategy is just understanding that intellectual property exists and that it might be something they need to worry about. For other businesses, most businesses, they are slightly more sophisticated than that. They understand that intellectual property in their business exists. They understand that they may want some registered intellectual property rights. They understand that they have some unregistered rights. And they think constantly about how they can secure some registration for some key property rights. Um, they consider importantly who needs to own the rights. Usually, rights that are registered spring from the efforts of one or two humans, but usually it is businesses that wish to ultimately own the rights that have sprung into existence from those humans. And so as part of an IP strategy for any business, one is looking around to see who within a business is likely to be creating new logos, brand ideas, or inventions. And one, as part of the IP strategy, needs to have in place a transfer system in place, legal documents, contracts of employment, or so called assignment documents. Uh, you also need to consider whether you've got some sort of contractor helping you out with your business, maybe helping you solve ideas or come up with cool new ideas. And you need to make sure that your business has legally binding agreements in place with such contractors to determine what you should and shouldn't consider to be the contractor's rights or the business's rights. When to think about protection is important, and the fact of the matter is, you should probably constantly be thinking about when you need to protect. There are a couple of key stages where it's definitely worth thinking about taking some positive action, particularly from a patent perspective. If you are creating a new invention and you wish to uh, try and protect that idea, you should be thinking about that during the research and prototyping stage. One of the problems is that with registration systems, it's a kind of a first to post game. And particularly if one is in a competitive marketplace, and particularly when various businesses are reacting to calls for solutions from large potential clients, perhaps where a large organization goes, "We are suffering from this problem. We need solutions to that problem. Here's some explanation of the problem." And they're just telling lots of people about that problem. You know that you're in a race. And so you're in this design, research and prototyping phase. There is a race to file a patent application because it is first to file that will usually end up owning the rights. It's also important to try and apply for patent protection before you make what's called a public disclosure of any underlying invention. Part of the test for whether you're going to get a patent is whether it defines an invention which is new. Newness is defined by what information is in the public domain, and a public disclosure, which could be putting it on your website, or you go into a conference where you're going to talk about it, or you're just going to go to a meeting with someone who's not under a duty of confidence to you. Uh, would be a public disclosure, and that public disclosure that you could yourself make would then defeat or stop you getting a patent for effectively the same thing, because you put into the public domain your invention before you actually apply for a patent. So you've got to file a patent application before a public disclosure. Another time which is critical is as you develop a product. So just because you file a patent application uh, doesn't mean that that is going to protect all of the subsequent developments that you make of that. The patent at its outset is defined by the documentation that you file at the outset. So as you are developing improvements, usually cool, better ways of doing some part of what you originally conceived of, you need to consider filing new patent applications for those new improvements, because there's a good chance they're not covered by the original documentation that you file as part of a patent application. And another good time to think about that is before any market entry, really just tidying up, grabbing what protection you can, because as soon as you enter the market and all your competitors look around and go, wow, we want a bit of that, they're gonna just try and copycat your ideas. So you want before that to have thought about whether there's any gaps in the protection that you've got. You also need to consider sort of where geographically you may want to try and protect yourself. The registered registration system of trademarks or patents or registered designs is territorial, geographically territorial by nature. If you want to secure some protection in, let's say, North America, probably the largest market for anyone, you need to get some US protection registered. If you are interested in the European area, which probably most of you would be, uh, you need some protection in the UK or France or Germany, or maybe it may occasionally be possible to get more sort of a pan-European right. Uh, so that's where, where what you might think there is, where are you based? You're probably most interested in the UK, making sure there's no competition in the UK at least. Where are your key competitors? Because most of these rights can stop your competitors doing things in other countries if you have rights registered in those other countries. You might want to think about where they're manufacturing. Perhaps if what you're trying to do is protect a product, maybe you're going to sell it in the UK or North America, so you need some protection there. But if you think that it's going to be manufactured, let's say cheaply, in some other countries, you might want to try and get some protection in those countries where you think manufacturing is likely to be happening. Costs obviously a complication on that. The more countries you try and get some protection on, the more cost. So it's going to be a balance um, on that one. For patents, this is a typical time frame. Usually, the time frame starts with an invention. So some groups of individuals within a business opposed a technical problem. They sit around for a period of time and eventually have a eureka moment. We call that moment of invention. And they talk to a patent attorney. It usually takes a month or two. to then file a patent application. That's illustrated on this timeline as 0, or the timeline which goes left to right. Usually within a year, 12 months, a patent application is filed, called an international patent application, sometimes called a PCT, or Patent Cooperation Treaty patent application. That is a single patent application that is valid currently in about 150 countries around the world as a patent application, not a patent, an application to be granted a patent. 18 months after your original filing date, all of the information that you put in your original documentation is published. That means it's put in the public domain. And it's at that information, it's at that point in time where all of the information you provided is taught to humankind, and you've effectively given away all of your information. There's about another sort of year, and then you hit this period, which is 30 months. So that's 30 months from your original date when you filed your first patent application. That's 2.5 years. And it's at that stage that you have to pick the countries that you ultimately want to try and get protection in if you go through this very common PCT route. It is quite common for companies that have applied for a patent application to pick 3, 4, 5, 6 countries. Let's say China, Japan, US, Brazil, and something called the European patent application. They get filed at that moment in time, 2.5 years from when you first file your patent application. And each of those patent applications can then lead to a respective national right. So a Chinese patent application filed at that stage can become a Chinese patent. It can be used in China to stop people making and importing, doing things in China. The Chinese patent application, if you get it granted, can be used in Japan to stop people making and using and selling, etc., in Japan, etc., etc. So here's some strategic costs to bear in mind. Again, you've got left to right time. To begin with, preparing and filing patent applications. So you create a new idea, you talk to a patent attorney. You're gonna spend £4,000 to £8,000, depending on how complex the idea is, to file a patent application. You're gonna then probably spend very little for a year. So during that year, you are marketing your idea like mad to see if there's any interest in your cool new idea. You file a single international patent application. A year later, ballpark another £5,000, something like that. So you then have another period of time. There's some very modest costs, a few thousand during this period. So you've got 2.5 years for, let's say, £10,000, £12,000. So in 2.5 years, you've had a good opportunity to see whether the world is interested in your idea. You've got your product on the market, you're seeing what reaction you're getting to the market, and you're doing that before this stage, because this stage is the custody stage. This is where you've got to do all of that, pick the different countries where you want a patent application. Each time you file a patent application in those countries, it's ballpark £5,000. And then each of those patent applications has a life of its own, and you are dealing with examiners that are objecting to things. You're dealing with us. We're trying to help you get patents. Each patent application is examined differently. Hopefully you get some patents. There's no guarantees that you're ever going to get a patent, but hopefully you do. That sort of tends to happen within 3, 4, 5 years down here. By that stage, because you've spent sort of 5 lots of 5, 6 grand here, you gain up to 50, £100,000 worth of charges around this stage. So once you get beyond this 30-month period, you're going to start burning some cash. Before that 2.5 year period, you're burning 10, 12 grand for an opportunity to get some patents. There's something called infringing a patent. So if you've created a new invention and you've managed to secure a patent, you can then technically try and stop some competitors from using that idea. Again, you've got this right to monopolize that concept for 20 years from when you filed your patent application. Um, and what patent attorneys like myself do is a client will come and talk to us and say, we do this, we've got a patent, or maybe you've got the patent for us. We've become aware of a competitor doing something the same or very similar. We need to stop them because they are taking money from our mouths. They're stopping us making sales, that sort of thing. And we advise clients on that. So it's about working out exactly what the patent covers. That's going to be dictated by what the words of the claims in a patent say. It's going to depend upon what the competitors are doing and geographically where they are doing it. And you need some legal advice if you get into that situation. You don't want to be making that sort of call yourself. Couple of quick comments about common intellectual property pitfalls. Uh, some of the biggest, um, publicly disclosing a cool new idea or a new logo or a new whatever, uh, really complicates your life at least, uh, can completely defeat any hope of securing protection. So, particularly for inventions where you might want to patent something, it is totally essential that you do not publicly disclose your idea before you have filed a patent application. That's non-negotiable. Don't do it. Another option, the common pitfall is waiting a little bit too long before you try and get some protection, try and register some, trademark or registered design or patents. It's kind of linked to the first thing, but if you don't take steps soon, you are constantly at risk that one of your competitors may beat you to it. If they apply to register a particular mark or uh, apply for a patent or try and register a design that looks virtually identical, chances are they're going to get the rights and you're not. So you can't just wait until you're making loads of cash. You've got to kind of think a little bit ahead. Um, Likewise, in different countries, once you've started the ball rolling, you have some rights. They're called priority rights. You've kind of got to try and get the protection in those countries within 6 months or a year, depending on the right involved. And you irrevocably lose the right to protect yourself in different countries if you don't act quickly enough. Um, there's probably an issue almost all companies are faced with, which is to do with ownership. I briefly talked about it. Most rights spring from the creative effort of individual humans. And what you need as a business is to be sure that anything that your employees or consultants devise on your behalf is owned by the company that you want to be ultimately the owner of those ideas. That's usually dealt with by written contractual agreements, contracts of employment, or consultancy agreements, or something called an assignment document. And there is a tendency to put that off because it's a bit fiddly and costly. And if you put it off, it comes back to bite you. You're better off doing it sooner rather than later. Some helpful tools that you should reach out to some advisors for: non-disclosure agreements. They can help. A non-disclosure agreement is a written document that says, I'm going to talk to you about topic A. You are not going to tell anyone about topic A. Both parties sign this and go, yeah, we're going to have a chat. It's about topic, whatever it is. And we both understand that this is a secret, confidential meeting. We're not going to tell anyone about it. They can be helpful. Not quite as helpful as not telling anyone about something, but they can be helpful. So get an advisor to give you a non-disclosure agreement for a particular event or contract or project that we've got on. Make sure your contracts with your suppliers are well worded and that they have clauses in them that touch on intellectual property. Occasionally, you can do some basic freedom to operate analysis. What that means is if you are about to invest in a project quite heavily, you can at least check whether some competitors have done exactly what you've done before. Can be quite costly depending on how much you want to kick the tires. But usually, if you're about to spend £500,000 on a new project, you want to spend a bit of money on due diligence at the outset, just to make sure that you're not going to walk into a brick wall. Um, you should be aware of something called patent box. If you get a patent and it, broadly speaking, covers some products or services that you sell, and you start making profit off those products or services, under certain circumstances, having patent can mean that you qualify for some tax relief. Can be quite significant. So you need to talk to your accountants about patent box. Some companies apply for patents and try and secure patents for the single purpose of securing tax relief off their profits for things that are covered. And you can also get some funding off the government for and advice for doing some due diligence, getting some IP strategy advice. There's plenty of available funding. It's relatively modest sums, but if you can get the government to pay £2,500 for doing an IP audit of your business, just to help you work out what rights you might have that are unregistered, or some rights that you might be about to sort of walk into that you could register. Uh, Businesses like ours, like Secerna, can help you spot things and give you some ideas. Right, conclusions, key takeaways. Your business owns intellectual property, just like your business might own other property. You've got to identify it and use it to your advantage. If you don't do something with it, you are potentially taking on risk, and you are almost certainly not maximizing your opportunity to benefit. Take action before it's too late. If you delay, you can lose the opportunity to register protection for things. Literally. So many times clients go, I got this great idea. No, it's like, and I have to tell them you can't do it anymore. So you've got to be aware of it. And unfortunately, the world doesn't wait for a time when it's convenient for you. IP strategy, talk about it with an advisor, someone like myself. What's important to you? What's financial and doable at any moment in time? We all work in the commercial world. We realize that, there's no unlimited pot of money, and IP strategies can change. So the fact that you decided to do something 5 years ago doesn't mean that it's appropriate now. Constantly talk to your IP advisors about it. It can appear complex, but we can help you through it. Right. That's kind of me at the end. My details are on the last slide there. As I say, very happy to answer any questions that you may have. Follow up with an email or feed them to Liam, and Liam can, I'm sure, send them through to us if he feels he can't answer them for you.
Thanks, Jason. That was absolutely fascinating.